Welcome to the John Crump News Channel, where we talk about news every day that we can. And today we're going to be talking about a new challenge to the NFA out of Texas. And I want to give a big shout out to John Jensen, who's the named plaintiff in the case, who is also watching the show sometimes. So thank you for doing what you're doing. Let's get into it. All right, we're going to be talking about this case. It is backed by the Second Amendment Foundation, Firearms Policy Coalition, the National Rifle Association, through their subsidiary, the Texas State Rifle Association, ASA, American Suppressor Association. It is being argued by the fine people over at Cooper and Kirk, and it is challenging the constitutionality of the NFA. It was filed in the U.S. District Court for the Northern District of Texas, the Amarillo division, and it is challenging the constitutionality of the NFA. And they have good reasons to sue. It's just like the other cases where they're stating that the tax, the $200 tax, was the purpose of the registration, and without that $200 tax, that um, that the registration is unconstitutional. And they have good reason to believe that. And we're going to get into that in a second. But first, let's go ahead and talk about John Jensen. John Jensen is a disabled person who wants to use an SBR because it's hard for him to shoot a full size rifle with his spinal cord injury. He had a spinal cord injury in 2000, and an SBR allows him to shoot. He was an avid hunter who has hearing damage, and that's one of the reasons why he wants to be able to use a suppressor. Let's go ahead and talk about the NFA. The NFA was enacted in 1934, and it enabled a $200 tax stamp and registration. That $200 would be the equivalent of around $5,000 today. Over the summer, there was something called the One Big Beautiful Bill that was passed through reconciliation, which lowered the tax to $0. It was signed into law on July 4th by Trump, and now it is giving grounds that the NFA could be ruled unconstitutional when it comes to everything but machine guns and destructive devices. The reason why there's a carve out for machine guns and destructive devices is because there's still a $200 tax stamp on that. But without the tax stamp, the NFA might fall short of constitutionality under Article 1 of the US Constitution. You might be asking, why do I believe that it might be unconstitutional? And there is a case that was from 1937 that dealt with the whole entire NFA being a tax thing. And that case was, I'm trying to remember what the name of it was. Whatever. Uh Cannot remember what the name was, but there was a case from there, and I don't have my notes. But there was a case from 1937. Oh, Svenvinsky versus the United States that challenged NFA, and the courts ruled that NFA is a tax measure. So if you take the Supreme Court saying it is a tax measure because that's what the Supreme Court said, and they have the ultimate decision on this, then it's not Miller. Miller dealt with short-barreled shotguns. Then it cannot be constitutional because a tax has to have a revenue raising purpose, and a $0 tax does not have a revenue raising purpose. So therefore, it has to be unconstitutional if they rule the way that they should. Now, a lot of people are going to be talking about the Peterson case. Peterson is also another viewer of the channel who's a pretty good guy, and that is the United States versus Peterson. And the United States versus Peterson, the Fifth Circuit upheld the suppressor regulation. But Peterson is also asking for an en banc review. The Peterson decision out of the Fifth Circuit was a three-judge panel, and he is asking for an en banc review. There's a great chance that the Fifth Circuit is going to take the en banc review, and if they do that, it could change what Peterson said. Let's say it's granted en banc. That would mean the panel's decision is vacated. Peterson's decision dealt with a person having an unregistered, unserialized suppressor, and they were challenging that on a few different grounds. So this case is definitely distinguishable from there, especially because part of the challenge is that the new law, the new reconciliation bill that passed has a $0 tax stamp. This is one of many cases. There is another case by ASA and SAF, and there is one by GOA, FRAC, and Texas challenging the constitutionality of the NFA as applied to not only suppressors, but short-barreled rifles, short-barreled shotguns, and AOWs. All those things had their tax stamp reduced to 0. So we are going to have to see what happens here, but I think we do have a good shot of at least one of these lawsuits defanging the NFA. We're gonna see when this goes up, but right now it has to go through a district court level. The district court will decide, and then whoever loses is going to appeal to the Fifth Circuit Court of Appeals. And then we start off with the three-judge panel, the en banc after that, before any of these cases have a chance to get to the Supreme Court. Just wanted to bring your attention to this case because it is very interesting, and the Bruin historical test is going to be interesting in this case to see if it works out. The Bruin historical test says history and tradition in plain text. Basically, you look at the plain text of the Second Amendment and you apply it to the conduct at hand. Uh, Jensen and the other people, they're all members of the people. Therefore, they're covered by the Second Amendment and SBRs, SBSs, and suppressors are in common use. So, therefore, it should be A-okay. But we'll have to see. Once that's all approved, it goes to the state where the state has to present historical analogs from the founding era to prove a law is consistent with the history and tradition of firearms regulations in the nation. Right now, I don't think that they could produce those those regulations. What they're probably going to do, and this is something that I've seen pop up a lot, is they're gonna take the dangerous and unusual thing, and they're not gonna claim that suppressors are not in common use. What they're gonna do is say the Constitution only protects firearms in common use, but that doesn't necessarily mean it protects all firearms in common use. I've seen this pop up in a few different cases around the country within the last year, and I think we're going to be seeing this a lot more because the Bruin test, most of these gun laws just plain out fail. So they're going to go back to Heller and they're going to modify common use to say that no, a gun can be banned if it's in common use. It's just those are the only guns that the Second Amendment protects, but it doesn't protect all firearms in common use. It's just something that they do. Very, very interesting. But I will be watching this case to see exactly what happens in it, and hopefully we will have an update within the next few months. I don't think we're going to see anything anytime soon, especially with the shutdown. A lot of the cases out there, the government has been asking to stay until the shutdown is over because the employees, the lawyers for the DOJ, are not working right now because of the government shutdown. So that's going to delay this case, and that's going to delay a lot of cases. We're still going to get decisions on things that's already been argued, but as for cases, we might have a little pause. So there might be a little slow period coming up here, which I could definitely use, but there's always going to be breaking news. So I will bring that to you every chance I can get. With that, we are going to get out of here. Thank you so much. And also, if you want to donate to the Scouts, you can go to givesendgo.com/997. And if you're a company out there and you want to sponsor a couple of videos, let me know. 100% of the proceeds will go to the Scouts for every video that I represent a company for. All right, guys, that's it. And I will see you guys later. Have a good day and stay safe and have a good weekend. Happy Columbus.